Hello and welcome to the presentation on protecting your intellectual property. My name's Meg. I'm a Business Engagement Manager at the Intellectual Property Office. The IPO is the official UK government body responsible for intellectual property rights. This includes patents, designs, trademarks and copyright. If you have any questions, you can submit them in the chat box function and we'll answer them when we can. So first we're going to cover trademarks. So what exactly are trademarks? Well, trademarks are badges of origin which distinguish the goods or services of one commercial undertaking from another. Trademarks are registered for specific goods or services within 45 individual areas known as classes. It is possible for others to register identical or similar marks as long as they're in a different unconnected class. For example, polo car, polo mint, or polo shirt. It's all about if you as a consumer would get confused and walk into a shop to buy a packet of polo mints and come out with a car because you confused the brands. If something is distinctive in its field, then you could potentially trademark it. A registered trademark can be represented by the R in a circle. TM can be used regardless of whether a trademark has actually been registered or not. The only official symbol is the R in a circle. This should only be used when a mark has reached registration and it's a fence to use prior to the registration status being updated onto the register. So what can be registered as a trademark? You can register names, for example, Chanel, logos, for example, the Nike tick, domain names, for example, diy.com for B&Q, slogans, for example, probably for Carlsberg, color themes, for example, orange for EasyJet, shape themes, for example, Toblerone Peaks, an action, for example, Asda's pat on the back pocket, and music, for example, the T-Mobile jingle. The mark must be distinctive for the goods and services you provide. We'll go into these in a bit more detail later on, but first I want to cover what can't be registered. You need to think of your trademark as a brand or mark of origin. It needs to be distinctive and unlikely to be confused. The point of a trademark is so consumers can identify clearly who is providing the goods or services that they're purchasing. Your trademark can't be offensive. It can't describe the goods or services you're providing. You also can't use words or shapes in common usage in the class of goods. For example, you could use a picture of an apple for computers, but not for greengrocers. You can't use language like the best or imply that your product is better than others in the same industry. You also can't use protected emblems like national flags, the Red Cross symbol, or the Olympic rings. You need to be unique and distinctive. Don't piggyback off another brand. Be the brand that other companies want to piggyback off. It's important to search for existing trademarks before you register because it can help you avoid expensive mistakes if you spend the money applying for a trademark that already exists. By searching, you can be aware of any competing trademarks in your area of goods or services, and it will help with the early resolution of any potential problems with other companies. You can find the trademark register on our website, ipo.gov.uk. The website also gives you a lot more information about trademarks that may be helpful. So how much does it cost to apply for a trademark? Well, in the UK, an online application costs £170 for one class and then £50 for each additional class. You can apply for this on our website. You can't change your trademark once you've applied and the fees are non-refundable regardless of whether the trademark is granted or not. You can use the Right Start service if you want to check your application meets the rules for registration. With this, you pay £100 initially plus £25 for each additional class. You'll then get a report telling you if your application meets the rules. If you then choose to continue with your application, you have 14 days after getting your report to pay the remaining balance. For trademarks outside the UK, you can apply to the EU IPO for protection in the European Union member states. We are still covered under this at the moment, but this will change from the end of this year. There is a fee of €850 for one class, €50 for a second, and €150 for any more additional classes. You can also apply to the World Intellectual Property Office for an international trademark using the Madrid Protocol. The World Intellectual Property Office have a fee calculator on their website, and the price you pay depends on how many countries you register in. If you need any professional advice, it's best to contact the Chartered Institute of Trademark Attorneys. So now we're moving on to copyright. Copyright protects your work and stops others from using it with your permission. You get copyright protection automatically. You don't have to apply or pay a fee. And there isn't a register of copyright works in the UK. Copyright is protected under the Berne Convention, where copyright exists the moment the work is fixed, rather than requiring registration. Because there's no official register, you may need to provide proof of when the work was created. Copyright covers literature and artistic works, for example, books, films, music, songs or sound recordings, photographs, paintings, manuals, databases, and dramatic works. Copyright doesn't protect works in the public domain when copyright has expired. It also doesn't protect ideas. It protects the expression of an idea, not the idea itself. Copyright also doesn't cover single words, titles, or facts. So who first owns copyright? Copyright will usually be owned by the creator or author, but there are some exceptions. An employer will usually own the work if it was produced in an ordinary course of employment. For example, a teacher may create lesson plans and visuals for their class, but the copyright to these will be owned by the employer. This will be in most employment contracts, so it's something to watch out for. A contractor will retain ownership of the copyright unless their contract states otherwise. This is a really important one when you are either a freelancer or contractor yourself, or your business hires contractors, as they will automatically own the copyright unless it is signed over to the business. This doesn't need to be a long legal document, just a small section of a contract that states who the IP will belong to once work is completed. If a creator sells their copyright, they still retain moral rights over how it's used, so bear that in mind when buying copyrighted materials from other people. Most copyright will last for the creator's lifetime plus 70 years. There are some exceptions. For example, published editions last 25 years, TV and radio broadcasts 50 years, and sound recordings 70 years. But in general, the copyright will last for the lifetime of the creator plus 70 years after their death. Tips for copyright. Record your work and keep proof. You can post something to yourself and keep it sealed with the postmark. Get things signed and dated and independently witnessed. You should keep rough drafts, sketches, chains of emails and agreements, high-resolution files, keep any negatives or other digital and raw files if you're dealing with photos. Keep rough drawings and plans for sculptures or early tests of things. It's all to build a picture for a judge in court, who must decide who's actually put their artistic craftsmanship into a piece of work if you get challenged or infringed. Use contracts. As I said before, make sure that all contracts stating who owns the copyright are in place as soon as possible. You can also license out your copyright for a fee of your choice. This license can be for a certain period of time or for certain uses. It's completely the copyright owner's choice. There are no official registers for copyright, but there are unofficial registers that you can use. They don't prove ownership, but they do prove that the work existed at the point of upload. Now moving on to registered designs. The Registered Designs Act of 1949 describes designs as the appearance of the whole or part of a product resulting from the features of the lines, contours, colors, shape, texture, or materials of the product or its ornamentations. In other words, what a product looks like. This could be anything from furniture to clothing, jewelry, shoes, kitchenware, sculptures, any products that have a physical form. You can register the whole product or just part of a product, depending on what you want protected. There are, however, things that a registered design doesn't protect, such as how the product functions. For example, a chair that folds down more quickly than others of the same kind. This would be something that a patent may protect instead, or if a patent is not applicable, then potentially something that could be protected by non-disclosure agreements or trade secrets. The same goes for how it's manufactured. This would also be protected by non-disclosure agreements or trade secrets. Registered designs also don't protect products that must be a certain shape or form in order to work. For example, a key must be the shape that it is in order to fit in a lock. Therefore, the shape of the key couldn't be protected by a registered design. Registered designs are a fairly cheap and straightforward form of protection for your products. It costs £60 for a paper application or £50 for an online application for one design. However, you can submit up to 10 designs in the same application for £70. These designs do not have to be related to each other, for example, product line. They just have to be filed at the same time. It then costs an additional £20 up to and including every further set of 10 designs within the same application. You can register your design online. It's fairly straightforward, and you can also get help from our information centre as you go through the application. Moving on to patents. So patents are protection for inventions. They cover new inventions, how products work, and their technical function. Patents can range from technology to pharmaceuticals and anything in between, but there is some criteria that must be covered before a patent can be granted. To be eligible for patent protection, the product must be new and novel, as prior disclosure will invalidate an application. It must also be an invention or at least have an inventive step, and it must also have a technical effect. It must do something. The actual costs for a patent aren't too much. To apply online, it costs £60 for the application fee, £150 for the search fee, and £100 for the examination fee. However, as the patent application process is a particularly difficult and complicated one, we do advise that you seek help from a patent attorney who can help you ensure your application is suitable. You can renew your patent every 5 years up to 20 years, or 25 years for pharmaceuticals and agrochemicals. I'm just going to cover some tips now, so some tips to take away. Respect other people's IP. Treat other people's IP like you would want yours to be treated. Decide if you actually want to protect and register your IP assets. There is no legal requirement to do this. It's completely up to you. Check if your brand is already registered as a trademark. Before you even start producing materials or anything to publicize your brand, just check that it's already registered, if it is or not, because you might get into some issues if it is already registered. Check you have the correct licenses to play music or radio. If you have any sort of public space, which includes an office, you must have a license to play music or the radio. Also check you have the right software licenses. Ask before using other people's photographs, as images from the internet may still be covered by copyright. You should check counterfeit products don't exist in your supply chain. This is a difficult thing to do, but it is important that counterfeit products don't get into general everyday use. Keep your invention a secret. You can use things like non-disclosure agreements and confidentiality agreements. Make sure you know who owns the IP. Check with contracts. Make sure that they are all secure and you know who owns the IP in a business. And we advise that you seek professional advice if you are applying for patents. Thank you for joining us today. We hope you have enjoyed this session. Just to remind you, if you have any questions, please do not hesitate to get in touch. You can contact us through our social media channels, as shown on screen, or through our information centre, details of which can be found on our website. That concludes the webinar for today. Thank you for listening.